Welcome to Rebel Chaser. My name is Gail, and I've got a video for you from Judge Nelson in Texas. And this one gets a little heated, so I'll just let you guys watch.
All right, this time we're recording and on the record on Bell County Calls number 24 DFAM 349-6967, and this is in the 169th Judicial District Court of Bell County, Texas. And this is in the interest of Kabbalah, a minor child, not the custodial party being Dalton L. Smith, the custodial party being Mia Rayanne Kabbalah. And this matter is before the court on original petition to see the effective parent-child relationship with AOP. We're operating under a current further temporary orders. And at this time, we're coming in to finalize this matter, or attempt to finalize this matter today. Both parties are present. The ad litem is present. The state is present. And at this time, I'll ask for an opening from the ad litem to tell the court what the ad litem is requesting we do here today, whether or not it's requesting the final, based on the information that the ad litem knows, and then let the state make an opening to tell the court what the state's requesting. Again, for you lay people, I don't let non-lawyers make opening statements. They don't get it right. They make closing arguments. So at this time, but at the end of the hearing, if either you wish to make a closing statement and or a closing argument, you'll be allowed to do so. Any other fact that you are your own representatives in this matter, or what we call pro se litigants, you represent yourselves without counsel. So the state, so I'll allow that at the very end. But this time, I'll start with Mr. Brimhall and then go Mr. Gwynn. Thank you.
Yes, thank you, Judge. Here's my understanding of where we sit. The court was last on this case on the 12th of September. The court entered a further temporary order, which set temporary support. I believe the temporary support amounts were $535 in child support and medical support of $148, both beginning October 1st. The retro was confirmed at that time for child support of $62.89 and 54 cents, covering a time period from 7/22/24 to 9/12/25, with a repayment of $77 a month beginning 10/1. The final hearing was reset for today. There were instructions that drug testing, which had previously been ordered that wasn't finished, be done and arranged again for Mr. Smith. Mr. Smith did get the test taken, and I have circulated the results for that, and I'll offer it into evidence later. I believe on the visitation issue, the court had a prior, I'll say the first temporary order, which put in place supervised visits, I believe, for up to 3 or 4 hours, if I'm not mistaken, at Slovacheck's in West Texas, or any other location the parties agreed to. At the further temp hearing, the parties, I believe, more or less agreed that there were approximately 5 to 7 different individual Saturday visits. Some of those occurred at the museum, at the Kids Museum in Waco. Some occurred at the zoo in Waco, and some occurred at Slovacheck's in West. The most recent one, I don't recall the date right off the top of my head, but it ended poorly. Police were called, and that was in West Texas. And then at the further temp hearing last time, the court temporarily suspended all periods of possession from Mr. Smith. So that's, I believe, where we stand. My understanding from the drug test result for both of the parents is as follows. The mother took her test at the beginning of September before our last, before the further temp hearing, and her result indicates a negative for all substances tested. And the result from Mr. Smith, which was done on 9/19, about a week after our last court date, which is the date that we arranged, him and I, was a Friday. And the result from that was negative for everything with the exception of and Delta 9, which were both positive. So those are the only positive hits on the drug test report. This court had previously ordered Mr. Smith to pay $300 in court costs at that final temp hearing. I think that was to be included in the final judgment, but it was made at the further temp hearing to pay back the county for the cost of the drug test result, or the drug testing rather. The court had reserved the issue of any other court costs. There was limited non-disclosure ordered for both parties, with the exception of the parties' email addresses, and that was the only thing that was to be disclosed between the parties was the email addresses. The parties are using AppClose to communicate and have been, I believe, for quite some months. And the issue of what the possession and access schedule should be, I believe that the following recommendations were made, which I'll re-urge here. The exchange of the child should occur within Bell County. The child was born in Bell County. The mother has not relocated from Bell County since the birth of the child. And the father is the one who did relocate from Bell County to south of DFW. I'm not sure what county it is off the top of my head, but it's south of DFW. And then the final order should include a step-up schedule until the child reaches the age of 3. The court had indicated that at the last hearing that if there were a failed drug test, the court would factor that into a decision on the possession and access schedule. And looking over the rest of my notes, the following geographic restriction was to the state of Texas on limited further temporary order basis. I'm not sure if the court wants to revisit that at the final, perhaps limiting it to Bell County and the DFW collection of counties might be appropriate in this case. And that's all I have, Judge.
All right, thank you. Mr. Gwynn. You muted, sir.
I apologize about that, Judge. To reflect what the ad litem had informed the court, the state is looking to finalize the numbers as we had been ordered in the temporary orders, and that would reflect a child support set at $535 per month, a medical support of $148 per month, and a retroactive judgment of $6,289.54 per month, repaid at a rate of $77 per month. The state's going to defer to the ad litem on all issues regarding access, possession, non-disclosure, etc. So we're just looking to get a final based on those numbers.
All right, thank you. All right, this time, folks, let's get some information from the parents and let's see what we're going to end up doing with this one. So I'll ask both of you to unmute yourselves at this time and raise your right hands. All right, you both solemnly swear or affirm the testimony you're going to give here today is the truth, the whole truth, and nothing but truth will help you.
Yes, sir. Yes, sir.
All right, you're both officially under oath, and I'll allow the, I guess we'll go ahead and start with you, Mr. Bramhall, since you obviously, the state's pretty much told the court what they were requesting, and based on the information I've already had, we received, I'm pretty much going to go with that. So the majority of the rulings that have to be made will have to be made on your recommendations and what the court has to do as far as access and possession going forward. So at this time, I'll start with you, Mr. Bramhall, and then we'll go to Mr. Gwynn. And then at the end of the hearing, I'm going to allow closing arguments from the lawyers and then from the individual parties. So at this time, I'll go ahead and start with you, Mr. Bramhall. Thank you. You're muted, sir.
Thank you. I would first offer the 2 drug test results into evidence. I emailed them to Belinda about.
I got them. I'm gonna mark both of these together as ad items 1. Any objection, folks? Ad items 1. Well, I'll keep them separate. Ad items 1 is yay.
The one that says Omega on the top is the mother's.
Okay, so mom's is going to be ad litem 1, and dad United States drug testing is ad litem 2. Any objection to either of these coming in evidence this time, ma'am? Ma'am, this is your, I'm asking yes. Stereo pair, I mean, I'm sorry, ma'am, your name's not okay, Ms. Cavada, any objection to states 1, ad litem 1 and ad litem 2 coming in evidence, ma'am?
No, I don't have any objections.
All right, Mr. Smith.
No objections, Your Honor.
All right, 1 and 2 are admitted. You're admitted. I'm sorry, you may proceed. Thank you.
Thank you. Okay. Okay, I'll call Miss Kanaba first. Can you hear me okay?
Yes.
Were you able to hear my opening request? Okay.
Yes.
All right. And so I know I emailed it to you. The court just accepted it into evidence, but you've seen the drug test result, correct?
Yes.
All right. And you took this before our last court date on the 9th or on the 6th, sorry, is that correct? Or the
Yes, off the top of my head, I do not remember what date it was.
okay. But your result indicated that it was a negative result for all 10 of the substances. Is that your understanding?
Yes.
All right. Have you taken any of the substances that were tested for since the 6th of September?
No.
Okay. Okay. Regarding the possession and access, you and Mr. Smith, is it true or not true that y'all have not had any agreed upon periods of possession since our last court date?
Yes, we have not communicated since our last court date.
Have you, okay, just to be clear, have y'all met anywhere to conduct a supervised period of possession?
No.
Okay. Have y'all attempted any phone calls between the child and Mr. Smith?
No.
All right. What county are you presently living in?
Bell County.
Are you living closer to Killeen or closer to Temple?
Killeen.
All right. Do you have access to a motor vehicle?
I was recently in a car crash, so a vehicle registered to me, no, but I do have access to a vehicle, yes.
Was the car crash since our last court date?
Yes, that was September 12th.
Oh my gosh. I'm sorry to hear that. Okay. Are you feeling okay? Was there any permanent injuries from the car crash?
No.
All right. Was the child in the car when the car was in the crash?
Yes, she was strapped in her car seat.
Were you at fault for the crash? What was there a determination made by the insurance company?
I have no idea. It's not my insurance, it's my mom's. So
I guess I should be clear, or I should be more specific. Were you driving or riding as a passenger?
I was driving.
Okay. All right. Briefly describe what happened.
I was driving to go get food.
Mr. Bruno, that's not going to have anything to do with my visitation going forward. So.
I just want to, okay, but you weren't under the influence, is that correct?
No.
Okay. All right.
You're just asking if she's been arrested for anything.
Yeah, what was anyone arrested as a result of the incident?
Oh, no.
That's where I was going, Judge. I just wanted to, okay.
Oh, okay. I was wondering about that one.
Yeah, well, yeah. All right. And you have a valid driver's license, correct?
Yes.
And it's not suspended?
No.
Okay. Okay. And you weren't cited, you weren't given a citation at the accident?
No.
All right. So is that your mother's vehicle that was
Mr. Grandma, move on. I don't care about the wreck, okay?
Well, I think that was her only vehicle at the last hearing.
Well, it was pick up and drop off. We're going to be in Bell County, so we'll see whether or not she has access to doing something at a neutral site somewhere here in Bell, either DPD, KPD, Nolanville PD, Harker Heights PD, somebody's PD, all right?
I guess, is the vehicle totaled or is it still drivable?
Oh, it's not drivable. It's currently in the shop.
Okay, so it is being repaired and can be used in the future. That's what I'm asking.
Yes.
Okay, very good. And so that's the vehicle you anticipate using on a daily basis to transport the child to and from activities and appointments and whatnot?
Yeah.
Okay, very good. Now, I believe at our last hearing you had mentioned that the child was born in Bell County, is that right?
Yes.
And the child has not ever lived outside of Bell County, is that correct?
Yes, that's correct.
All right. And you and Mr. Smith did not reside together at the time of birth, is that correct?
Yes.
Okay, and the two of y'all have not resided together in Bell County since the birth, is that correct?
Yes.
Okay. Regarding the preferred plan for period of possession, can you briefly describe what you would prefer or like for this court to do as it pertains to periods of possession between the child and Mr. Smith?
I would like no visitation, but I see that that is not an option.
No.
So, the 1 to 4, from 1 o'clock to 4 o'clock, is acceptable. I agree to that for her to get dropped off. Other than that,
Here's the deal.
really
I guess-
I'm gonna
I guess
stop. Here's the deal. I'm gonna short circuit all of this, okay? He's still coming in from the Metroplex going forward. The next level up I'm going to deal with is, well, he'll be able to pick the child up at 11 a.m. on Saturday or something like that, and then have the child back home by 5 p.m. That's where I'm going to start with, okay? And he's got to come to Bell County to do that, and I'll set it up every the first, third, and fifth weekends of the month. But that's what I'm looking at doing based on the information I've already heard in all these hearings. So, and Dad's got to, and I'm looking at the exchange like I say, at one of the appropriate, the closest police departments. All right, and like I said, I'm looking at that 6 hour. I'm looking at that 6 hours to be the start, and doing it starting out at 3 times a month, up to 3 times a month. And then we'll deal with everything else going forward after that, after I hear some more testimony. Thank you.
So his pickup would be 11 a.m. to 5 p.m.?
Yeah, 11 a.m. on Saturday to 5 p.m. on Saturdays.
Okay.
That's what I'm thinking.
So yeah, at the prior hearing, I believe there was some discussion about a step-up plan. Do you recall any of that or talking about that?
Yes.
All right. And the step-up plan, as it's described, it's designed to increase the periods of possession as the child gets older, as time goes on, eventually leading to a what's called the standard possession order at some point in the future. Is that your understanding?
Yes.
Okay, and you're in agreement with some step-up plan as determined by the court, correct?
Yes.
Okay. Do you have any safety concerns regarding Mr. Smith? Just yes or no, please, on that one.
Yeah.
Okay.
Yes.
Are those concerns related to the result of his drug testing or other things?
Drug testing and other things.
Okay. So the drug testing, in a nutshell, are you concerned that he may be under the influence of during a period of possession?
Yes.
Okay. And regarding the other things,
Again, now you can only
without getting
you've been an eyewitness to, not some, or what he's told you, not something someone else is that you heard from someone else. Thank you.
before, I'm trying to craft my question so that it doesn't lead to a long answer, Ms. Kanaba. But what I really want to know is a bullet point list of what the other things are. So just give me a bullet point list of what you would categorize as the other things that concern you.
Safety.
Okay.
Safety and with Harper.
Okay, a little more detail.
Drinking and driving, Again, being under the influence of aggression. I mean, he was aggressive when we were dating, so I mean that would
Okay,
prolong.
stop. Yeah,
Um,
speculate on something like that. Sorry,
At,
thank you.
at the, did, may we proceed, Judge?
Yeah, go ahead.
Okay. Um, at the last period of possession, there was
I remember all that from last time around, Mr.
okay.
Well, let's not rehash. Okay, the
Yes,
court
are those
the incident, the Hillsborough hater. All right,
yes.
go ahead.
The um go ahead and correct me if I'm wrong, but I believe that there was only the blow up at the last incident. Is that right?
yes. Excuse
Okay.
me, I'm gonna get a charger for my iPad real quickly and move destinations. Thank you.
Okay. Yeah.
Proceed, I'm listening.
Oh, okay. All right. I didn't sure if you had to stand up or anything. Okay.
Oh no, you're good.
Regarding how old is the child in years in months?
Ooh, he is 1 year old. I don't know how much that is in months though. I just go by 1 year old by telling people.
But she okay. All right. Okay. Her birthday's in the summer though, so she's over a year and 3 months or so.
Yes.
All right. Is she enrolled in a daycare at all?
No, sir.
Or any kind of other uh education program or anything like that?
No.
Okay. Um, are you presently working?
I have a interview tomorrow.
What okay. Um, is that interview a formality? Do you anticipate getting it, or is it just
I do anticipate it getting.
okay. Do you know what the work schedule would be?
Afternoons from 6 p.m. till closing.
And do you know, is that 5 days? Is that Monday through Friday or what?
Oh, sorry. Yes. Monday through Friday, 6 p.m. to closing. Weekends open availability from morning to whenever.
And what time is closing for the? Is it a restaurant or what type of business is it?
It's Dutch Bros. I want to say that they close latest. I want to say 10 or 11.
Okay, all right. Um, all right. If you're working, do you have family or friends in the area that you can rely on to get your child to a designated drop-off point?
Yes.
All right. I'll pass. I think I'm okay.
All right, then, Mr. Quinn, you're a witness.
Alrighty, Ms. Canava. So you heard that the numbers that we were ordered in the previous temporary order, correct?
Yes, if I want to be sure, 535, and if you can relay it back to me.
Okay, I'd be happy to do so. So you understand that in the previous temporary order, a child support of $535 was ordered per month, correct?
Yes.
And you understand that there was a medical support of $148 per month that was ordered, correct?
Yes.
And you understand that the retroactive judgment was taken as of the 12th of September of this year to be $6,289.54, correct?
Yes.
And you understand that that would result in a repayment of $77 per month towards that arrearage, correct?
Yes.
Okay. You understand that the state is looking to finalize this order, to get a final order, and to basically use those numbers going forward. Do you have any objections to that?
No.
All right, I have no further questions for this. Oh, actually, I have one further question for this witness at this time. How's the child receiving medical support? Or medical?
Medicaid.
Okay, so government medical?
Yes.
All right, no further questions for this witness. Thank you.
All right, thank you. All right, you may call Mr. Brimhall. Anything on redirect?
Do you anticipate moving out of Bell County at any time in the next year?
No.
I guess, okay. Is there any chance you'll move closer to DFW?
No.
Okay, all right, I'll pass.
All right, then, Mr. Brimhall, call your next witness, please.
I'll call Mr. Smith. Can you hear me, Mr. Smith?
Yes, sir.
All right. Have you been able to hear both the opening statement and all of the questioning and testimony thus far?
Yes, sir.
All right. Do you, regarding what county do you live in?
Johnson County.
And how long have you resided in Johnson County?
Last 2 years, at least.
Do you anticipate relocating from there closer to Bell County?
Nope. No, sir.
All right. And I believe we addressed this at the last hearing, but it's over 2.5, 3 hours to get to Bell County. Is that correct?
About 2 hours, yes, sir.
Okay. And do you take 35 or a back road?
35.
All right. I had offered, and it was admitted into evidence, your drug test result, indicating that it was positive.
I believe, Mr. Brimhall, I sent you my medical certificate, my certificate and the card, an email weeks and weeks ago, multiple weeks ago, under House Bill 46 in the Texas Compassionate Use Program.
Okay, so were you prescribed
I was
marijuana?
prescribed, yes, sir, and gummy 10 milligram gummies for my back pain, my neuropathy, and my anxiety
Okay. How frequently do you use all that?
every night, so I can sleep.
Okay. What do you do for work?
I'm a welder.
Has your job situation changed since November or early September?
Yes, sir. It has. I moved to a new company called Work Steel Fabrication. Same amount, same hours, just different company.
Okay. Okay. What are the side effects of the that you're using?
The drowsiness. There's not really any side effects. I guess it just hunger, uh, sleeping, drowsiness. That's really the only two things I can think of. It just helps. It just helps me sleep at night, so I'm not tossing and turning because of my back pain or my mind constantly running on end. It's just supposed to help even me out so I can sleep and sleep good.
Okay. Do you um have you been arrested or do you have any pending criminal matters?
Not that I know of, no, sir.
Okay. Regarding the uh step up plan that's been discussed at this hearing and prior hearings, uh what is it that you're asking for regarding your periods of possession?
Well, I'm guessing you didn't receive I tried to text you last week and today also about what I was wanting to do moving forward. Yeah, I just in recent light of certain things and the way everything's going and how much I just want to stop this here because I feel like I have a better chance of my daughter wanting to come know me in the future than having to go through every hoop and I'm being forced to live like a criminal because I want to see my daughter. And a woman who absolutely hates me is getting her every day. I have no relationship,
Okay,
so there's
so
nothing to fight
I'm
for
gonna
from my
object
end.
I'm gonna object to
Stop.
non-responsive.
I want to out. I just want to release
Mr.
I just want to
Smith,
relinquish my
stop.
rights.
Mr. Smith, you weren't okay. He said stop. I'm saying stop. Mr. Brimhall says stop. You're not in trouble. I say stop. You in Bell County Jail for up to 6 months. Okay. We don't put. This is not television. This is not drama. You listen to the question, you answer the question, and don't go off on the deep end on me, sir. Because again, this is a court of law. If you're sitting here right next to me in the courtroom, you might be in handcuffs right now. So here we go. All right. So I'm going to go ahead and let the state, I'm going to go ahead and let Mr. Brimall finish asking you questions, but listen to the questions and answer the questions. And but right now you're saying you won't stand a visitation or you because of mom or whatever. Well, you have that right, sir. But the bottom line is don't start going into some explanation of why you're saying what you're saying. You just answer the question, please. Thank you. If Mr. Brimall wants to expand, he will. Thank you. You may proceed, Mr. Brimall.
So sorry, I had lost connection, Your Honor.
All right, no problem, ma'am. We stopped the hearing, and you may proceed, Mr. Brimall. Thank you.
Okay, Mr. Smith, can you hear me? You're muted.
Yes, sir.
Okay, so my understanding is that you don't want to exercise your periods of possession and or would like to voluntarily terminate. Is that a summary of what you're saying?
Yeah, I'd want to voluntarily terminate my rights. Yes,
Okay,
sir.
do you understand that a
Go ahead
motion?
and tell him the facts of life on that one, Mr. Brimall. Thank you.
Okay, you understand that there's no pending motion or request to the court to do that today?
I want to do it.
Okay, but do you understand it's not possible for the court to do that today?
So how do I do that?
Okay,
The lawyer.
okay.
Our
Well-
lawyer, sir. And here's the deal, sir. The odds are even with a lawyer, you're gonna be able to get it. Courts don't let people out of their responsibility unless there's somebody else willing to take up that responsibility. If there's someone out there willing to adopt, that's fine. But right now, this is your child, sir, and you have a legal right to, legal obligation to support and a legal right to have visitation. So if you don't want the right to have visitation, you still will have the legal obligation to support no matter what, sir. You may proceed, Mr. Brimall.
Okay, Mr. Smith.
And I'm sorry, Mr. Smith, you can go talk to any lawyer in Johnson County you want, and they're probably pretty much going to tell you the same thing. But you can always talk to someone to see about doing it. Thank you.
Okay, do you understand what the judge told you on that, Mr. Smith? You're muted. You're muted. We can't hear you, Mr. Smith. You're muted.
I wish not to go any further until I get a lawyer now. So
Okay.
Well, sir, I'm going to you can do that, sir, but I'm going to go ahead and rule today. You can go
you
ahead
can
and
rule, sir, but I would rather not be here for it.
Sir, this is a free country. You can log off anytime you want.
Thank you. Y'all have a good day.
All right. Goodbye, sir.
Okay. Well,
Good enough.
I guess I have no other questions.
All right.
May I ask what that means for me?
It means I cannot tell you what it means for you if I hadn't ruled yet, okay?
Oh, okay.
Thank you.
Yeah. Okay.
All right, yes. Then now that Dad has done what Dad did, do you have any questions you want to ask? I'll go back for Ms. Galan at this time, Mr. Brimall.
My next question to Mr. Smith is going to be, can he drive down here? But do you know if Mr. Smith has a car that he can drive down here?
I've only seen
Mr.
one
Brimall,
car
it doesn't matter whether or
used,
not he
that's
has
what
one or not. I set up the visitation. If he comes here, he better do it legally, otherwise it might be problematic. But again, I don't have to. I don't ask anybody do they have a car any visitation hearing. So you may proceed with anything else. So thank you.
I think I'll pass. I do. Well, sorry. One of my final requests. I'm going to add a request. I think it would be.
But you can do that in closing, sir.
Yeah, I'm going to add a request that Mr. Smith take an anger management course as part of my closing.
Okay.
Ms. Kanaba, do you think that's a good idea?
Yes. Yes.
All right, I'll pass.
All right. Anything on? Do you have any other questions of Ms. Kanaba, Mr. Gwynn?
No, Judge, state does not.
All right. All right, Mr. Brimall, I'll go ahead and let you make your closing statement. Then Mr. Wynn, and then ma'am, if you wish to make a closing statement, closing argument, you can. You may proceed.
Judge, here's my request for final. My request is that the geo restriction be I guess I'm fine with it just staying state of Texas. There's no indication that either party is going to leave the state anytime soon. My request regarding possession and access is that Well, number one, I do think Mr. Smith should take an anger management course. I think he
Okay,
should.
that's okay.
In the-
Geo restriction, anger management ordered.
Um, and then I would request that he obviously be ordered to not use any uh, substance that was tested for within 24 or 48 hours before any period of possession. I understand he uses it for pain relief. He had testified before he logged off that he used it under doctor's.
Okay, this deal, sir. I was going to order him to get you a copy of his prescription and an authorization from him to contact his medical doctor, confirm that that is an actual medical necessity and a legal right he has under Texas law. But since he kind of bailed on us, I'm still gonna make that part of any type of order going forward before I'll go any further past the initial first one or two steps for visitation. Thank you.
Mr. Smith did send me. I can't authenticate him. Obviously, it looks very. That's why.
Again, that's why I was going to have to get a copy of it and get his authorization to contact his physician and have the physician verify that this was correct. All right.
Yeah, he sent me some things, but I can't.
I can go on and use even Google AI and Microsoft AI can all do that kind of stuff and get to some of those serious ones. Yeah, it really gets
Right. I wasn't confident in their authenticity, so I didn't present them to court. That's what he was talking about. But
again,
he did send me.
I was definitely thinking about that before he went off the reservation. So, and that's not.
But my request is that he just not use it prior. I mean,
okay, I got my ruling on this one ready, so go ahead and keep going.
Okay. And then on the step ups, I think 11 to 5 or 11 to 3 or whatever it is.
It's gonna be 11 to 5, and that's the only one I'm gonna give him for right now.
Yeah, I think that's appropriate. I think him. I mean, he had messaged me much earlier saying he wanted to terminate. I didn't respond. I didn't think it warranted a response.
Yeah, that's the old fall. That's the old fallback for the last 20 years. I want to give up my parental rights. Well,
No.
tell him to Google that and see how easy that is. All right, you may proceed.
Obviously I'm opposed to that. But yeah, his behavior has not been great at court. I will remind the court that he was held in
Mr. Grimmer, I
contempt.
just saw it. I'm not gonna give anything past this initial visitation period for 11 to 6. So you could, and he's gonna have to give mom so many days notice, and we're still gonna use that close. So yeah, you can just go into that. Thank you.
Yes, my request would be that he confirm his visits for at least 72 hours in advance. That they meet at, I believe the Killeen Police Department would probably be the closest to the residence of Miss.
All right, ma'am, where do you live? Do you live in West Killeen or East Killeen or Harker Heights or Nolanville? Which city?
Closer to Harker Heights.
All right, we're okay. Then it's going to be Harker Heights PD.
Okay.
Or Killeen's way, that's a good distance away. So yeah.
Okay. And then I would just request that be altered as she moves to whatever the closest PD is to her residence.
Okay.
Regarding court costs, I'd ask that Mr. Smith, obviously the court's already ordered 300 for the.
And I'm going to make a date certain within the next 15 to 20 days. The next time you're coming back to court, Mr. Brimhall, I need to confirm whether or not he's made that. I'm going to order to make that payment on it before that date. And it's going to be part of the court order. And if he has not done it by that date, I'm going to keep you on this matter to file a motion to hold him in contempt for failure to pay that.
I will need to reach out to the clerk's office because I don't want to speak for the clerk's office, but my understanding is they do not usually assess court costs, even if they're technically ordered. Or they don't send out bills for court costs. So
I'm ordering him to make the payment to the Bell County Register only before a certain date. Once we finalize this, and you look up what date in the next 20 days you're going to be back here in court on another matter. Okay.
Yes, Judge. I think it'll take the clerk's office some more time to make sure they send out a bill.
It's got a bill. It's all part of the court order, and he just makes it through the registry of the court. Okay.
Yes, Judge.
Yeah.
He was previously ordered held in contempt and probated that for 5 days, 5 days in the Bell County Jail for previous outbursts at court. That sentence was probated for 24 months, so I would like that included in the final order.
Okay.
And then court costs, so there's the 300, whatever other court costs the court may feel is appropriate.
Whatever costs Bell County bills, if they bill it, it goes to him, and he has until the 31st of October 2026 to pay that.
If I could have perhaps a little longer, just because the clerk's office, my concern is the clerk's office isn't going to be able to invoice that and send it out.
I'm sorry, what?
For the court costs, doesn't the clerk's office have to send that out?
He needs longer than 1 year and 30 days?
No, just like 60 days instead of 20.
Oh, no, because it's become a final. Let's see.
I see.
Wait a second. Let me go. Just go ahead and continue with everything else, and I'll consider whether or not you can. Yeah, I guess I can still give you 60 days to file a motion for enforcement. I guess that wouldn't be a problem. Go ahead. Thank you.
Okay. The step up plan.
Step up. It's just one.
We covered it. We covered it. Yes, Judge.
Yeah.
The temporary support, as it's previously been.
Requested amount for child support and cash medical going forward as per the year, and we've already done the retro, so and the repayment on that, so it's all going to remain as requested and approved. So
that's all I have, Judge. And then I guess I need a date for my release. I guess at some. And that's
okay, you look at a date that you're going to be coming back in mid November, and I'll look at that as being your date if he makes the payment. Okay.
All right.
And you can text him and let him know he has to make that payment. Otherwise, the court has authorized you to file a motion for enforcement against him, which means he could get 180 days in Bell County plus a fine.
I'll be here on the 4th, 5th, and 6th, so any of those days will be fine.
That's only 30-something days, so I thought you wanted a little bit more than that.
Oh, okay, yeah. Well, whatever day the court, I have the 20th, but I believe that's a Coryell County day. So whatever, I know December 3rd is fine. Maybe that's an enforcement day. Maybe that's
yeah, okay.
But
all right, well, you're not going to be here. I'll give you a date that you have to check in by, no matter.
Okay. And then the last issue is non-disclosure. The court had originally ordered it for both parties. I would request that the mother's address be kept out of the final order. The father's address. I don't know if there was any sufficient testimony to support that at this hearing or the last hearing.
All right. Well, I'll grant for mom and not for him. Thank you.
All right. And that's all I have, Judge.
All right, Mr. Gwynn.
Yes, Judge, state's not going to object to any of the matter of non-disclosure or acts of possession, anything like that. I would just, perhaps being redundant, like to object to any request for termination of rights or
that's way above my pay grade.
Oh, yeah, as a matter of policy, I want to say I object on the record, but I understand it's not exactly on the table.
Right.
That being said, again, the numbers as previously discussed, I'd like confirmed and to turn this into a final order, and that's all the input I have on this one, Judge. Thank you.
All right. Yeah, Judge Cornish and Judge Sims can do that, but I can't. So they're the associate judges in Bell County. They can do that. So here's what I'm looking at doing, ma'am. I'm going to go ahead and keep the we have them as currently joint management service, correct?
Yes, Judge.
Okay, I'm gonna still keep it as joint manager with the right to side domicile, ma'am. I'm leaving that with you, and you can live anywhere within the central time zone of the state of Texas. Don't move to El Paso, in other words. I'll go ahead and grant the child support, cash medical, the retro as previously ordered, and the repayment of the retro as previously ordered. At this time, I'm going to go ahead and order the visitation package to be the 1st, 3rd, and 5th Saturdays of the month from 11 a.m. to 5 p.m. With him, and that is he will be able to pick your child up at the police station in Harker Heights. And for right now, so long as you live in and again, you can move wherever you need to in the state of Texas. If you move further away from say you move to Temple, then it'll be Temple PD, but it'll always be the closest PD to that. But you will need to send him a notice through AppClose that, I live now in another city and this is the closest PD. You don't have to give my address, just a city. And going forward, and the current order will limit that to Temple, to Hart Heights PD until further notice that you live to a closer PD. I'm going to go ahead and order that he pay the court costs, give him a year, and to the 31st day of October 2026. I'm going to go ahead and order him to pay the cost of the drug test. Wrong calendar. Sorry about that. Let me bring up the right one. And now that I got my calendar in Zoom's calendar system back up and running, I'll open that. There we go. Let's see what we got next month. All right. Let's do that. No, let's do the week, 2 weeks before Thanksgiving.
Judge, the cost of the drug test was $299.
Okay. All right. Okay, that's why, because I was supposed to be doing my advanced family. That's falls. That's that. That's that. Oh, okay. All right. I tell you what, Mr. Brimhall, let's go ahead and move it to December, and let's use the first general docket in December, which will be Tuesday, the 2nd of December, as the date that I'll reset this to confirm that he's made that payment by, and I'll hold. Well, it doesn't matter whether or not it's a final. Well, it doesn't matter whether or not the orders become final or not. I'll leave you on this until further order of the court releasing you, and I will not look at releasing you to at least that date on December the 2nd, and to see whether or not that you need to file a motion for enforcement against Dad for paying the court paying that fee. So, and I'll look at doing it at reset to 9 a.m. on December 2nd. General docket, ma'am, you do not have to appear on that. That's just do some administrative items in this matter, just in case. I'm going to go ahead and order court costs, as I said earlier, get into to the end of October to pay that, and non-disclosure, as I said earlier, and visitation, as I said earlier. So, is there anything I specifically have not already ruled on? Because I think we pretty much did that throughout the closing. That you need me to rule on at this time, Mr. Brimhall, and then I'll ask Mr. Gwynn.
So the court cost was the $299 plus whatever.
No. The $299 is for the he's already repaid that specifically for the drug testing. I'm also ordering he to pay court costs if billed by Bell County, and he has until the 31st of October of next year to pay that.
Okay.
And I'll go ahead and say he's got to the 30th of October. 30th of November to pay the court cost on the $299. And that when we come back on the 2nd, if he hadn't paid it, then I'll give you permission to go ahead and enforce.
Okay. All right. Let's see, the exchanges are at the police department.
Hart Heights PD.
Yeah. The step up is it's just one step. It's not even a step.
No step. That's the court. That's the visitation to further order the court, because again, we had not been able to confirm whether or not he is actually has a legal right to use any type of marijuana or cannabis product. Again, he just testified to it, but he offered no proof, and like I said, he stormed out before we can order him to make that proof. So, and you can put in the court order until Mr. Gwynn and to further order the court and proof upon him being able to use some form of medical marijuana cannabis product in the state of Texas.
Okay.
All right. Anything else, sir?
There was some. Did you want the 11 to 5 visit to occur within Bell County or?
Okay, restricted to Bell County.
Okay. All right, I'll pass.
All right. All right, Mr. Gwynn, anything else, sir?
I have nothing at this time, Judge.
All right. All right, I'll ask you to prepare. Ma'am, do you have any questions?
No, sir.
All right, the state's going to prepare that order, circulate to you and Mr. Brimhall. Again, Mr. Brimhall is going to show back up on DEC2 to confirm that whether or not the father's made the payment, and I'll give him authorization to do it. I'll go ahead and keep the order suspending on the prior 5 days, and but if he doesn't make that payment in time, then he's probably looking at somewhere between 30 and 180. It just depends. So, Mr. Primar, you can let him know that he definitely needs to make that payment. Otherwise, the court's going to look at ordering him into Bell County for that. So, all right. All right, then, Mr. Gwynn, thank you very much. Ms. Kanava, thank you very much. I'll let the state and Mr. Brimhall finish that documentation and get it to me. And we're officially off the record. Good luck, ma'am. And we're off the record. Thank you.
Thank you.
Well, that one took a left turn awfully quick. But I can completely empathize with him because I see so many cases where the father gets the shaft. He gets screwed. And I typed this out. Someone posted that one time and I saw this and I just thought it was perfect. Visitation is for prisoners, not parents. I don't understand why in most situations it can't be 50-50. I mean, the little ones were made 50-50, right? Why can't, for most situations? Well, I don't know if that's appropriate in this situation. But, he said this person that hates me gets her 100% of the time. So I understand it. I understand where he's coming from. He feels completely frustrated. She's probably blocked him at every turn. And the only thing is, he went about it completely, well, that's not the only thing, but he went about it completely wrong. What he should do is, if he really wants to see his daughter, he really needs to scrape together some money and get an attorney, because that will take him out of answering these questions. Attorneys know how to phrase things and put things that are perfect in court. So that would be my advice. Get an attorney, get a good attorney, and let them handle it. That way you don't get your anger up and it's all with your attorney. That's just my opinion though. Anyway, I just thought this was interesting because, mom gets everything now because he walked out. He should never have done that. Get an attorney. Hopefully he'll see this. Get an attorney. And the judge, the judge was uncalled for, in my opinion. He was awfully rude to him, and he didn't need to be. So, anyway, thank you guys so much for watching, and I'll see you another time.